Okay, we're on the record in the state of Florida versus Nikolas Cruz. I intended that this case be set, what I'll call the homicide case, be set today to discuss future potential dates for pre-jury selection. Then I was asked to add the aggravated battery or attempted aggravated battery case to the docket for housekeeping matters. And then I come here today, and there are very many people sitting in the courtroom, and I was informed that this may perhaps be some type of a plea. So if, and Mr. Wheeler, it's very nice to see you back.
Thank you, Judge.
We're happy you're doing well. So you all, I'm going to leave it up to you to let me know what's going on, because apparently I'm the last to know here.
We're in the same boat.
Mr.
Judge,
Wheeler.
The defense is requesting that the court sit these matters down for a change of plan Wednesday of next week when lead counsel for the Parkland case can be here. She's currently out of state and she filed a notice of unavailability for this week. But it's our intent to enter a change of plea as to both cases to all charges.
Okay, I have no problem setting the lead homicide case on Wednesday for a change of plea as long as the state is available on Wednesday. However, I have 109 members of the community that are coming back on Monday morning at 8:30, and or actually 55 and then 55 at 1. I don't want to bring those individuals back and inconvenience them if in fact we don't need to do that. So if Mr. Cruz wants to plea on the attempted aggravated battery case, that needs to be done today, because as we all know, people change their minds. I'm not going to excuse those jurors until the case is pled, and I don't want to have them come back if that's the intention. So that case needs to be pled today, whether it be this morning or this afternoon. The other matter, I don't have a problem waiting for lead counsel.
Judge, it's up to the court what the court wants to do. Obviously, the court has to accept the defendant's guilty plea. I think that if the court feels that it doesn't want to inconvenience the members of the community, I understand it completely. I would ask that it be, rolled to Monday. If the court wants to do that, I would ask that my client be dressed out for court for the change of plea as to any case, either the Parkland case or the Beltran case.
Well, it's only 20 to 11 now. So what if the sheriff's office, if I were to ask them and they would agree to put him, to dress him in his trial clothes, and we can come back at 1 and do it? Because I can't, even if it's only 55 people, that's 55 people that have to drive all the way, find parking, pay for parking. I really don't want to do that unless it's necessary. And again, folks often change their mind. Not that your client will or won't, I don't know, but that happens where somebody changes their mind, and that's why I don't want to excuse them until I've taken the plea. I find, I accept the plea and it's all set, we have the paperwork, and I make the requisite findings.
Judge, I have the paperwork in hand if that ameliorates the court's mind at all.
But he can, until I go through a colloquy with him, he could change his mind, and again, because we have already started the trial on that case, I want to do that today. I'm sure that I can arrange to have him dressed.
And Judge, just so that we're clear, we're asking the court to impose a sentence on Wednesday on the counts 18 through 34 in the Parkland case to 17 consecutive life sentences.
Well, we don't have to, I think that's premature as far as discussing that. I first need to take his plea, and it needs to be on the case that we've started the trial on. And then I'll schedule the plea on the other case. But for today, may I see...
We have Captain Carter in the back there. Sorry to call you out, sir.
May I see you for a moment, sir? Thank you. I don't want to embarrass him. Okay, thank you, Sheriff's Office. The Sheriff's Office has indicated that they can have him up here dressed in 15 minutes. And then I can give you all time to go over the stuff with him if you need to, and I can put the white noise on, take a recess, let you do that, and then I'll accept his plea.
Judge, the state would raise the issue of competency only as far as I've been advised that the defendant has been evaluated for competency and has been found to be competent as recently as this morning. And we want to make sure that part of the plea colloquy addresses that.
Well, I always ask people whether or not they've been diagnosed with a physical or mental illness, what it is, whether they're taking medication. That's part of my standard colloquy.
Just,
Judge, I have no issues as to my client's competency at this time.
Okay.
and it hasn't been raised in this case, but since I know that he was evaluated this morning, I just feel
Sure,
like it
I
needs to be
always
placed
go
on the
over
record.
that. That is part of my standard plea. All the lawyers in here know, I think, Mr. Wheeler, you would be familiar with my plea. And I go over that in depth to make sure that the person can make a knowing, voluntary, and intelligent waiver of all of their rights, so.
Thank you.
Okay, so we'll be in recess for 15 minutes. The sheriff's office is going to bring him up, and then Mr. Wheeler or Mr. Ehrman, however long you need to speak to him, you can let me know, and then I'll accept the plea, okay? Thank you.
Thank you.
Who's my point person from the public defender's office?
I am Judge David.
Okay, Mr. Wheeler, I either need your client, I need to be able to see him, so if he can either stand up or come to the podium, and you all are, of course, welcome to come with him or stay with him. Okay, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. Please state your full name for the record.
Nikolas Cruz?
Are you currently under the influence of any alcohol or illegal drugs?
No, no, ma'am.
Are you taking any medication?
Not at the moment. Nope.
Okay, when you say not at the moment, do you mean not today or not in the past month?
I have taken in the past, but nothing recently.
Okay, and by recently, are you talking a week, 2 weeks?
About like probably a year.
Okay, so you haven't taken any medication in a year.
Nope.
All right. Do you suffer from any physical or mental illness?
I was told in the past, but I don't believe I have any issues.
Okay, what did they tell you? You said you were told in the past.
I was told in the past that I suffered like anxiety, depression.
Okay, and but no formal diagnosis.
No formal diagnosis.
All right, and how are you feeling today?
Feeling all right.
I understand you're nervous. I assume you're nervous. That's normal. But
Yep.
what I need to know is, are you feeling any type of anxiety to the extent that you would not be able to understand or follow along with me when I'm speaking to you?
No, I understand.
Okay, and you're thinking clearly,
Yes, ma'am.
and you understand me when I'm speaking to you?
Yes, ma'am.
And are you having any trouble communicating with your lawyers?
No, I am not.
Okay, and do either of the attorneys have any reason to believe that Mr. Cruz's competency is compromised this morning?
No, Judge, I don't.
Okay. Sir, how old are you?
I am 23 years old.
And how far did you get in school?
I got to 11th grade.
Do you read and write the English language?
Yes, ma'am.
Have you gone over the charges and the charging document with your lawyers?
Yes, ma'am.
And have you gone over the plea form with your lawyers?
Yes, ma'am.
And have you read each and every paragraph that's listed in this 2-page plea form?
Yes.
And are these your initials here? Showing.
Sorry, I didn't-
You all can. Do you want to take it?
Glasses.
I just want to make sure that you are the person that initialed, or perhaps you read it and someone initialed on your behalf.
Yeah, these are my signatures.
Okay, so you initialed each paragraph as you went over it.
Yes, ma'am.
Okay, thank you. Now, sir, also state, did you give me a score sheet?
And the prison, of course you have a prison.
Thank you. Thank you. And has the defense had the opportunity to look at the score sheet?
Yes, Judge.
All right. So I'm going to go over your charges with you now. In count 1 of the information, you're charged with attempted aggravated battery on a law enforcement officer. That's a second-degree felony, and it's punishable by a maximum of 15 years Florida State Prison. Do you understand?
Yes.
Count 2, you're charged with battery on a law enforcement officer. A third-degree felony punishable by up to 5 years Florida State Prison. Do you understand?
Yes, ma'am.
Count 4, you're charged by information with depriving an officer means of protection. It's a third-degree felony and it's punishable by a maximum of 5 years Florida State Prison. Do you understand?
Yes, ma'am.
Count 4 is attempted use of a self-defense weapon against a law enforcement officer. That's a first-degree misdemeanor, and it's punishable by up to a year in the county jail. Do you understand?
Yes, ma'am.
Do you understand each of the charges as well as the maximum possible penalty that can be imposed on each charge?
Yes. Yes, ma'am.
Okay? Sir, under the Florida Criminal Punishment Code, that's your score sheet. With these charges alone, you score 14.40 months Florida State Prison at the bottom of the guidelines. So I have the discretion to sentence you from a period of 14.40 months Florida State Prison up to and including the maximum penalty on each and every charge that I just went over with you. Do you understand?
Yes, ma'am.
Okay, it's also my understanding that this is an open plea to the court today. Is that correct, Mr. Wheeler?
Yes, ma'am.
Which means you are asking, as opposed to negotiating a plea with the state, you are pleading to the court and asking the court to impose what I believe to be a fair and appropriate sentence in this case. Do you understand?
I understand.
Do you understand that I'm not making you any promises or guarantees as to what sentence I will impose at this time?
Yes.
Okay, has anyone made you any promises or guarantees as to what sentence would be imposed if you were to plead open to the court today on these charges?
No, ma'am.
Has anyone threatened or coerced you into entering into this plea?
No, ma'am.
Have you had enough time to speak to your lawyers? And when I say lawyers, that could be Mr. Ehrman, that could be Mr. Wheeler. You have the benefit of having a team of lawyers. So when I say lawyers, I'm speaking individually of them and of them in the collective or as a group. Are you satisfied with their services?
Yes, I am.
Is there anything else that you feel your lawyers need to do on your behalf that they have not already done before you enter into your plea today, sir?
No, ma'am.
Do you understand, sir, that by entering into a plea today, you are waiving several constitutional rights, including the right to require the state to prove each and every allegation against you beyond and to the exclusion of a reasonable doubt? Do you understand?
Yes, ma'am.
You're waiving your right to have a trial in this case. Now, as you know, we have begun jury selection in this case, and as soon as the jury was selected, we finished the selection, which I assume would happen Monday, we would start the trial. And at the trial, the state would have to prove by testimony and evidence each and every allegation and each and every element of each charge against you beyond a reasonable doubt. And if they could not meet their burden of proof, the jury would have to find you not guilty. Do you understand?
Yes, ma'am.
And do you understand that by entering into a plea, you're waiving your right to require the state to prove these charges?
Yes, ma'am.
Do you understand you're giving up the right to have your lawyers confront and cross-examine the state's witnesses who are called to testify against you? Can we?
Jennifer.
Is
Ms.
there,
Gutenberg?
is there a way we can mute?
You have to mute it on your system, mute all
How do I do that?
on the Zoom. In Zoom.
It's not coming on the screen. It's on the other screen. Go back to you.
Okay, she just muted.
Okay, just keep it.
Yeah, but I'm still gonna. How do I mute everybody?
You have to click on the little microphone. Don't click on those, they all muted.
This person's not muted.
No, that's that,
That's it, this,
that's that.
that's this one. Good.
No, don't mute
All right, sir, do you understand that you're giving up your right to have your lawyers confront and cross-examine the state's witnesses who are called to testify against you?
Yes, ma'am.
Just like your lawyers confronted the state's witnesses at the motion to dismiss, they would again have the opportunity to confront in that type of manner all of the witnesses that would be called to testify against you. Do you
Yes.
understand?
Yes, ma'am.
However, but by entering into a plea, you're giving up that right. Do you
Yes, ma'am.
understand? You're also giving up your right to remain silent and not have that held against you in any way whatsoever. Do you understand?
Yes, ma'am.
If you were to choose not to testify at trial, I would tell the jury that they could not hold that against you under any circumstances. Do you understand?
Yes, I understand.
You're also giving up the right to present testimony and evidence or a defense on your own behalf if you have one. Do you understand?
Yes, ma'am.
Finally, sir, you're giving up the right to appeal the judgment and sentence of the court. Do you understand?
Yes, ma'am.
if you were to take these charges to trial and have a trial in this case, and after trial you were to be found guilty, and either your lawyers or yourself or an appellate lawyer were to believe that either myself or one of the attorneys committed reversible error, you would have grounds to appeal the judgment and conviction. Do you understand?
Yes, ma'am.
Do you understand by entering into the plea, you're giving up that right?
Yes.
Do you also understand that if you were to go to trial and you were to be convicted of one or all of the charges or some of the charges, that you would have the right to appeal my ruling on the motion to dismiss, which I denied. But by entering into a plea, you're waiving your right to appeal and take that issue to a higher court. Do you understand?
I understand.
You're giving up your right to appeal any issues that have been decided pre-trial. So any motions that were heard and not ruled upon in your favor could ultimately be appealed if you were to go to trial and you were to be convicted of one or any of the charges. But by entering into a plea, you're giving up that right. Do you understand?
Yeah, I understand.
Okay, do you have any questions about that?
No, ma'am.
In addition, sir, I need to advise you that the state is going to be using this conviction in this case as evidence of an aggravating factor for purposes of arguing in favor of the death penalty. Do you understand that?
Yes, I do, ma'am.
And do you understand that you understand the meaning of an aggravating factor? Is that correct?
Yes, ma'am.
And has the defense counsel gone over the concept of aggravating and mitigating factors with their client so that they are confident that he does understand what they mean and how this judgment here today, or conviction, will impact him and his homicide trial?
Judge, I've gone over the pros and cons of either trying this case or entering a plea to this case and the impact that would have on the 1958 case.
Okay, and you're confident he understands what I say when I'm explaining to him about an aggravating factor?
Yes, Judge.
Okay, thank you. Okay, excuse me, is the defendant waiving PSI?
Yes, Judge. I've explained that to him also.
Right. Sir, if you are not a U.S. citizen, you will be subject to deportation under the laws and regulations of the Department of Homeland Security upon entering into this plea. Do you understand?
Yes, ma'am.
In addition, sir, if the offense to which you are pleading is determined to be a sexually violent or sexually motivated offense, or if you've been previously convicted of such an offense, this plea may subject you to involuntary commitment upon the completion of your sentence. Do you understand?
Yes, ma'am.
Has the state disclosed all items of physical evidence in discovery, Ms. Schneider?
Yes, we have, Your Honor.
And has the defense reviewed the discovery in this case with your client?
I have, Judge.
And is either the party aware of any physical evidence, if tested, that may exonerate the defendant of the charge or charges in this case?
No, ma'am.
State? You're not aware of any evidence that would exonerate him?
Your Honor, that would exonerate the defendant.
Okay, thank you. All right, Mr. Cruz, at this time, do you have any questions, either for me or for your lawyers? If you need to speak to your lawyers, I'm happy to give you time in private so that you can talk to them. I'm about to ask you how you wish to plea in this matter, and then there won't be any time for questions. So now is the chance. If you have any questions for me or your lawyers, just let me know.
I think I'm good.
Okay, you sure?
Yes, ma'am.
All right. Sir, in case number 18-14129, to count one of the information, attempted aggravated battery on a law enforcement officer with a deadly weapon, how do you wish to plea?
I plead guilty.
Count 2, battery on a law enforcement officer, how do you wish to plea?
Guilty.
Count 3, depriving an officer means of protection, how do you wish to plea?
Guilty.
And count 4, attempted use of self-defense weapon against a law enforcement officer, how do you wish to plea, sir?
Guilty.
Also, are you agreeing that your credit for time served at this point is 1,068 days?
Yes, ma'am.
Okay. I accept your plea of guilty. I find that you are alert and intelligent, that you understand the nature of the charges, that you understand the consequences of entering into the plea. I find that you have made an informed decision with the advice of counsel, and that you're knowingly, voluntarily, and intelligently waiving all of the rights that I just went over. Are the parties stipulating to a factual basis for purposes of the plea in this case?
Yes, Judge.
Your Honor, the state is prepared to prove by competent evidence that on November 13th of 2018, the defendant attacked Sergeant Ray Beltran, who is in the courtroom today. Sergeant Beltran was wearing full BSO gear and was in fact working at the jail, so the defendant was quite aware that he was a law enforcement officer. The defendant proceeded to kick, hit, punch Sergeant Beltran, attempted to remove Sergeant Beltran's electric taser, took that electric taser and attempted to hit Sergeant Beltran with it over the head as if it was a blunt object, and attempted to remove that from his person, thus giving a basis for all of the charges.
Okay, based upon the proffer supplied by the state,
Judge, we would stipulate as the facts as alleged in the PC.
Okay, the stipulation by the defense counsel, as well as my own review of the court file and my review of the video that was presented to me at a court hearing, I do find there's a factual basis for the plea, and
Your Honor, I'm just going to interrupt for a second because for some reason the printout that I gave you of the score sheet did not include the last charge, so I've added it. It makes a point of difference, but I would ask that we use the corrected score sheet.
did you give Mr. Wheeler a copy?
I will in a second. Let me add the
You
point.
sure it's not there? The point
No.
two?
It's not synced.
It's this one.
Maybe I get here.
Do you have a supplemental page?
No.
Good point two. Yeah, there's a point two.
There's a point two, but it wasn't listed, so I've listed it now.
So have you seen the corrected score sheet?
Yeah, I saw it when she handed it to you, Judge. It's fine.
Do you want to take a look at it?
It appears to be the same calculation, they just left off the charge.
Okay. But the ultimate calculation is by, it looks like he scored what I told him was 14.40 at the bottom, and now it's 14.41.
It's fine.
Okay, do you understand, Mr. Cruz?
Yeah, I understand.
advised you that the bottom, what we refer to as the bottom of the guidelines, or the lowest permissible prison sentence under the Florida Criminal Punishment Code was 14.40 months Florida State Prison. The state inadvertently left off the use of a self-defense weapon, which is a first-degree misdemeanor. When you add that misdemeanor, which is a .2, you come up with the lowest permissible prison sentence in months of 14.41, as opposed to what I told you, 14.40. Do you understand?
Yeah, I understand.
Does that change your decision as to whether to enter into this plea today?
Nope.
Okay. And is Mr. Cruz requesting a PSI?
We are not, Judge.
So you're waiving PSI?
Yes, ma'am.
Okay, and when are you all requesting to set the second case for a plea?
Wednesday, Judge, next week.
And does that date suit the state?
Yeah, that's fine, Your Honor.
So we'll do it Wednesday at 9 a.m.?
That's fine.
And how long do both sides anticipate this taking? Are there going to be, is it going to be anything other than a plea? Are you going to ask me to hear from anyone, Mr. Satz?
No, Your Honor, there's going to be another phase to it, so.
No, I understand, but I just want to make sure. So it should be an hour at the most.
Yes, ma'am.
Judge, I mean, we're going to ask the court to sentence him on counts 18 through 34 to 17 consecutive life sentences. So if the state would like to have their victims here to present their testimony, they'd have the opportunity to do so.
I'm not inclined to sentence him until the end of the trial. When I impose the sentence that's recommended by the jury, I would just sentence him at that time. Is there a reason you want him sentenced earlier than that? Because then we have to have testimony and evidence twice. I assume, Mr. Satz, if I were to sentence him on the non-homicide charges that you would want, would you then have people that would want to speak?
I'm sure we would, the victims probably would.
So it seems to me, we can do it all at once.
Well, Judge, the sentencing for counts 1 through 17 obviously is what the penalty phase is going to be for.
I understand.
realistically, what is the relevance of the counts 18 to 34? The state's seeking to not impose death on those counts, and they can't. But we can cross that bridge on Wednesday, Judge, if you want to do that then.
All right, but just so you know, my inclination is only to accept this plea on Wednesday. Now, for the original purpose that we were here, I asked that we do a status conference for the lawyers on the homicide case so that I could tell you which days I have set aside for pre-selection of jurors.
Judge, I would ask the court to entertain pushing that conversation off into Wednesday also. Ms. McNeil has filed a notice of unavailability for this week, but she will be back on Wednesday.
Okay, it was the whole point of this hearing. I'm confused why we're here, if that was the reason why I needed to meet with you all. I'm just going to say, this is what I'm going to let you know right now. I have had the clerk's office issue summons for jurors November 8th, 9th, 10th, 15, 16, 17, 29, 30, 31.
Judge, can you give me those dates one more
I'm
time?
sorry, yes. November 8th, 9th, and 10th. November 15th, 16th, and 17th. November 29th, 30th. And December 1st. Those are all Monday, Tuesday, Wednesdays. As well as December 6th, 7, and 8. And December 13, 14, and 15. I've made arrangements to have extra jurors summoned just for us. And those are the dates that I have set aside. That's 15 days. I think we can get through 250 a day. We'll use Judge Williams' courtroom. We have it all mapped out so that we can have up to 58 people socially distanced in that courtroom. And we can get through, hopefully, the better part of jury selection so that after the first of the year, we can start the trial. That's my intention.
Judge, I don't
But,
believe we're going to be ready to begin the jury selection on those dates, Judge. I would like Ms. McNeil here as lead counsel for the penalty phase to explain her need for continuance.
Okay, well, I'll consider whatever you ask me to, but that's the plan. Mr. Satz, you wanted to say
yeah, I
something?
just wanted to, put on the record again, Your Honor, we haven't received any witness lists for either the guilt phase or the penalty phase. If it's going to be mental mitigation, we want an opportunity to know who those people are and take their deposition, and if necessary, have our experts.
I understand. I was unequivocal with all the lawyers here, including Ms. McNeil, that this month was going to be set for Mr. Cruz's first trial starting October 4th, and then I set aside the entire week of October 18th and the 25th for all of the pretrial motions in the homicide case, and I was very clear that I intended that the trial was going to start after that. So there shouldn't be any need for any type of continuances. Everyone knew what was happening, and if they haven't been listed, then I don't know what to tell you. Maybe they're not calling any. But we're in recess for now, and I'll see you all Monday at 9 a.m. We're going to do it no, not Monday. You said Wednesday. Wednesday at 9 a.m. in Judge Williams' courtroom, which is, what is it, 7840.
You want us in Judge Williams' courtroom for Wednesday's change of plea?
Yes, we already have it all set up. I think there's more room, and it will be more comfortable for everyone, okay?
Judge, is it the court's inclination to adjudicate and sentence Mr. Cruz now on the Beltran case?
No,
Okay. You want to hold off until Wednesday?
I'm going to defer for now.
Understood.
Thank you.
Your Honor, this is Deanna Shulman on behalf of one of the media coalitions. May I just ask an administrative question about next Wednesday's hearing?
Okay.
Will you, there are some 70 of us, Your Honor, on Zoom this morning. Will you be amenable to making a Zoom link available for Wednesday's hearing as well?
It's my understanding from the Chief Judge that Court TV was planning to be here next week on Monday for the trial, so I would assume that they would be covering Wednesday's hearing, live streaming it, and that there would be an alternate room available. So if that is the case, I am not inclined to have a Zoom link because you all will be able to stream it from there like you did for the jury selection.
Okay, I will coordinate with Ms. Lunsford on whether that
Sure.
comes to fruition.
Or Joe
Thank
D'Amico
you.
from Court Administration, okay? Thank you.
And Judge,
Yes, thank you.
Mr. Cruz has been taken out of the courtroom, but the state's still here. Is it the court's intention to cut loose the 106th hearing?
Yes.
Okay.
What, I didn't, sorry, did
To excuse the jurors.
Oh, okay.
We're gonna, yes, thank you for reminding me, because we have to start calling. There's like 100. Go ahead.
Are you doing a disposition, adjudicating guilty and deferring sentencing?
Yes.
Okay. I mean, no and yes.
We're not adjudicating, Judge,
Oh, it says it right here, guilty, adjudicated guilty. No?
we, setting it off.
Hmm?
We're setting off adjudication, sentencing to 20, right? That's what we said.
No, he pled guilty. I'm adjudicating him guilty on all 4 counts, and I'm deferring on the sentence that's going to be imposed.
Okay.
What? I don't know. Do you have to ask me that this afternoon with everyone looking at me? Is there anything else for today?
It's Maria's case, but the defendant wasn't in a courtroom, I don't think, when you adjudicated him.
Okay, I'll do it again on Wednesday.
Okay. What?
Who signed it?
All right, anything else?
No, Judge, thank you.
All right, thank you.